Welcome back. You're still watching Politics Tonight, digging beyond the headlines, and now to our second interview for the day. I am joined by a lawyer and advocate for good governance, justice and equity, Libros Ashoma, for discussion on judges getting tough over frivolous cases. Thank you very much for joining us again tonight, sir. Thank you.
Yeah, my pleasure always, sir.
So let's begin with litigations regarding outcome of the 2023 elections. How will you describe the situation at various courts so far?
Yeah, so far so good. That has been the procedure before now, right from 1999. In 2011, there was improvement. In 2015, there were a bit of improvement also. 2019, there was a whole lot, of improvement. Some petitions that would have ordinarily been thrown away at the preliminary stage, because of the amendment to the practice direction and then the rules, objections were taken and then judgment reserved till, at the end of the cases. So there was improvement. So you hear the case to the end and then determine everything once. And then all those appeals, going on appeal over applications also, were stayed and they stopped. So it's all well. A lot have started at various states. Some are still waiting for pre-hearing. So it's, after 180 days from now, all of this will die down and then we'll see what happens. But at the Presidential Election Petition Tribunal also, it's been good. We've seen lawyers doing their thing, and the most important thing is that the judges have been on top of their game. And like they say, when the judge is on trial, the judge is on trial. And all of those pandering towards sentiment and the rest, the judges have not allowed the opinions to be swayed. Also, this idea of using social media to harm judges have consistently held out their own, and that's good for all parties.
So it's now very interesting to see how judges are going tough on frivolous cases. Why is this seemingly inevitable?
Yeah, it will become very inevitable with the advent of social media. I remember the last time I was on this program, I did say that one of the reasons why the Election Petition Tribunal will also refuse application for live hearing of the matter of the tribunal will probably be one of those issues of pandering. They would want to avoid a situation where people would rather pander to sentiment than the law. So with the advent of social media, where almost everybody is a judge, almost everybody is a lawyer, and you see lawyers also leaving the law to discuss sentiment on social media. Some of them are more interested in granting interviews after the case than fighting their case in court. And then some of them would rather want to impress the public or impress their clients than the fine letters of the law. So if the judges do not hold their own, if they don't put their foot down, some of them can be intimidated out of their seat. And so because the judges do not have the opportunity to also come to social media and begin to grant interviews and begin to, pander to sentiment. So that's why they wait for the lawyers, at the appropriate time to melt out, the appropriate sanction. And that's what is obtainable before now, even in, other societies, other jurisdictions that we copy, where lawyers waste the time of the court sanction them heavily. And so they know the implication of all of that, and so no lawyer would want to just go to court for going to court sake. But like in America, where people go to court frivolously because the legal system there is much more flexible than the rigid one that is practiced in England, and that ours is tailored after.
But some analysts blame this on desperation on the part of politicians. But why are lawyers allowing themselves to be pushed?
It is a politician can be desperate. It is now behoves on you as a professional to permit me to use the word, to cut that politician to size using your professional finesse and your superior knowledge. The presumption is that as a lawyer, as a professional, you have a superior knowledge of the law. You should be able to advise your client. I have had cases where clients come to me and insist, the law, we must go to court on this. And I tell you, there is no way there, no matter how much you're offering me, I would not want to go and waste my time in court because I know certainly the beginning and end of that matter. So, but a situation where lawyers allow their sentiments, their political leaning to overwhelm their sense of judgment or to overcloud their professional discipline. So you will not begin to now blame politicians that it is the lawyers are allowing themselves to be dragged by politicians. For crying out loud, the lawyer is a professional and he should act professionally. Let me give you an instance. A situation where a lawyer knows fully well, constitutionally, that a sitting central bank governor does not have the right or the law does not permit him to join a political party. He now says he wants to vie for the office of the president as a sitting central bank governor. Rather than resign, he employs a senior advocate who goes to court and says he wants to test the law. He wants to stretch the law. He wants to challenge the law. Which law are you challenging when there is no provision for such? And then the judge, you waste the time of the court, you waste taxpayers' money because the judge is sitting and being paid. You waste the time of printing papers that of the court. And I thought they do not even have jurisdiction to hear this matter, or that the matter is dead on arrival. Another one, election had been conducted. You all know, it's elementary law, what we call, even in contract, there's what we call privity of contract. There's what we call cause of action and right of action. Elections have been conducted, and then also there are jurisdictional courts. You know that for pre-election and post-election matters, you know the parties who should be, who can approach the court. Result had been announced, and you also know that by virtue of the Evidence Act, once results are announced, they are presumed regular until the election tribunal, not the Federal High Court, not the State High Court, not even the Supreme Court. The Election Petition Tribunal cloaked with the jurisdiction to handle those matters until they say otherwise. You know, you don't have any because you approach the regular court and say, invalidate this election on the ground that there is a constitutional question that should have been answered. And meanwhile, that same constitutional question is a matter that is pending before a superior court. Which lawyer does that? If judges do not sanction lawyers for doing that, then before you know, we will throw the profession to Harry can just read and file paper and say, please, I need you to certify madman.
All right, let me quickly ask you this. How true is it that Nigerians are the most litigious people on earth?
I do not have the data for that statistics, but I know that if our case laws are not lying, Nigerians really are really highly, and that is why the slogan "Go to court," has now become an everyday thing, where you sell a land to 5 different persons and you tell them go to court. Where, because you know the windmill of justice grinds slowly, we say of justice grinds slowly but surely, but we forget justice delayed, justice denied. You intentionally breach a contract, you say go to court. You borrowed money from somebody and you refuse to pay, you say go to court. You take out a property on a mortgage, you default in the foreclosure. To get a court order, you say little action, you sin and rush to court. In some cases, you find out that matters ordinarily that ought not to be in court are in court. So you get to court, sometimes you have 72 cases on a cost list, which is why that even the system of practice had been introduced, front loading of documents to streamline the time for court cases, because some of them you have, in some cases you have about, I also think that for political matters such as this, the best thing for the court to do is to come with heavy sanctions, including frivolous matters.
All right.
The court will come with sanctions on not just the litigants.
So what impact do you think this filing of frivolous cases will have on Nigeria's democracy?
You see, you're unfortunate that the judiciary,
Please go ahead.
Okay, then. Okay. So the judiciary has been so vilified that even when judgments and sanctions like this are melted out, it is also common for the public to say, oh, yes, it's because it's the government in power. Oh, the litigants are being hounded, you know, and all sorts. So, but if we take steps like this, ensure that frivolous cases, there are consequences, adequate consequences, and immediate and swift consequences for actions and reactions, all of these frivolous cases will find a way of limiting them. Also, we must also suggest that for election petition, for example, people have suggested that we need to reduce also further the time for hearing cases. Elections should be conducted on time, and then the time for determining, you know, cases should be before swearing in. That will also, in a way, reduce all of these frivolous cases. Dispose.
All right, I've been speaking with
a busybody for swearing in. These are assuring all parties, all hands on deck.
All right, you've talked about sanctions, you've talked about consequences, but apart from imposition of fines, what kind of sanctions would you like to see? What kind of disciplinary measures would you like to see? Did you get this, Mr. Libros?
The court had that matter that is under reference. You know this. So the court had asked that the case file be duplicated and referred to the legal practitioners disciplinary committee. And then in cases, apart from fine, you know, in some cases when you know that your license is at stake, that you are dangling your license in public, you will mind your own transits and you mind the kind of cases that you file, which is what happens in England. Licenses are suspended. Even medical practitioners' licenses are suspended for negligence. Here, lawyers, for the negligence of a lawyer, nothing happens. So I think that in the bar and the bench, there's need for collaboration and synergy, that where lawyers also, you know, go beyond their brief like this. There's need to look at how, you know, even licenses can be suspended. When this happens, I can tell you that before a lawyer will take up a matter, no matter the money involved, he will also look at his license and, you know, look at the consequences of such actions for just a few naira note.
So at this point, how will you advise lawyers to handle matters involving politicians and election litigations?
Yeah, I will, if what I do, this is my practice, cases where I know that the politician will not want to listen, even if the case is frivolous, I chase them with charges. There are some charges you would, there are some fee you would charge, and the politician would ask himself, why will I want to do this? So for lawyers, there's need for consistently update of the provisions of the law. As the laws are amended, the practice directions are amended, there's need for continuous education by lawyers so that you know which one is elementary, which one is not elementary. Also, the bar need to, I know they are doing a lot, but also there's need for all-inclusiveness on education of lawyers, not just junior lawyers, because some of these issues are done by old lawyers. Some of these frivolous actions are filed by even senior advocates. So there's need for an all-inclusive step to ensure are not just pamper lawyers a lot, should desist from this attitude of pampering senior lawyers who believe that they are overboard and that they can do anything and get away with it. So once that is done, at least that will also go a long way in ensuring that the bar takes the first step before the disciplinary committee does anything. And then finally, there's need for a review of cases. Any case that is filed before such case is assigned to any judge, there's need for good review the matter, and at that stage, decide that it is not worthy of being filed. Once you do that, you'll be able to keep a lot of cases out of the cost list. So most of the cases that are not, that do not really meet be sifted out at that stage, and then you reduce the number of cases.
All right, so that's for lawyers. But for politicians, what do you have to say to them about taking matters to court unnecessarily?
Yeah. Remember, I don't know if that fine was eventually enforced. You remember the Owerri, Imo State judgment of the Supreme Court. As bad as it was, we say the Supreme Court is final, not because they are infallible, but they are infallible because they are final. As bad as that judgment was, senior advocates still took the matter to court, asking court to whether interpret, respected senior advocate, asking court to whether interpret or review. And there was sanctions meted out on these lawyers, which I expected the politicians also to bear. Some of these politicians, the fine should insist that such fines petition. So when such is done, the politician will also think twice to ensure that they know what they are doing before even approaching a lawyer to file a frivolous matter, knowing fully well that he might go bankrupt for that.
All right. Finally, before we go, how much pressure does this put on the judiciary?
A lot. It's unimaginable. It's unimaginable pressure because you find out that the times for delivering judgment on cases that are not frivolous, you spend them on listening to and hearing frivolous applications, frivolous matters. In some cases, multiplicity of suits. So other cases that have substance are delayed because you have 40 cases, 50 cases on your cost list that you must hear. And out of these 40 or 50 cases, about 25 are cases that ordinarily should not get to court. And so it put pressure on the judge, it put pressure on the system, and at the end of the day, it also delayed the course of justice for the litigant. So that is why a government and a judiciary that is ready to move, apart from embracing technology, there's need for such to sit down with the bar to ensure that, this discussion on filing of frivolous application, these discussions on sentimental litigation, there should be a roundtable discussion on it. And recommendation made and truly, properly followed through. Because you find out that we have embraced technology in hearing matters. But when the number of frivolous cases keep coming up and this attitude of lawyers trying cases in the middle than in court, it is going to clog the wheel of justice and the dispensation of justice. And it is not good for any society that wants to move, because if your judiciary is not up and doing, if business people know they cannot get judgment swiftly, there are delays in getting judgment in your society.
Thank you very much.
Business would rather go to other countries. That's why quickly, you find out that in most business transactions in Nigeria, big businesses, they would rather put an arbitration clause to be determined in England than in Nigeria.
All right. Thank you very much, Libros Oshoma, a lawyer and advocate for good governance, justice, and equity. Thank you very much for your contribution on the program tonight. Thank you.